Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I am here with my co-host, and today we are explaining what a writ of mandamus is and how it can end an immigration delay.
This is the foundational episode of the series. If someone is researching immigration delay lawsuits for the first time, this is where they should start. We are going to cover what mandamus means, where the legal authority comes from, what courts require for a successful claim, and how federal judges evaluate whether a delay has become unreasonable.
Let's begin with the fundamental question. What is a writ of mandamus?
A writ of mandamus is a court order that compels a government official or agency to perform a duty that the law requires them to perform. The word mandamus comes from Latin. It translates to "we command."
How far back does this remedy go?
This is one of the oldest remedies in the common law tradition. It dates back centuries in English law and was incorporated into the American legal system from the beginning.
How does mandamus apply in the immigration context?
When someone files an immigration application with USCIS or another agency, that agency has a legal duty to review the application and issue a decision. Mandamus is the remedy when the agency fails to fulfill that duty. A mandamus lawsuit asks a federal court to order the immigration agency to adjudicate the pending application.
So what exactly does the court order when it grants mandamus?
This leads to a critical distinction. Mandamus compels a decision. It does not compel a particular outcome. The federal court is not deciding whether the applicant qualifies for a green card or citizenship or asylum. The court is not substituting its judgment for the agency's judgment on the merits of the immigration case. The court is simply ordering the agency to do what it is already supposed to do, which is review the application and issue a decision.
So the applicant still has to qualify on the merits.
Right. The applicant still has to meet the eligibility requirements, but they are entitled to have their case actually reviewed. They are entitled to an answer.
Where does the legal authority for mandamus come from?
The primary statute is called the Mandamus Act. It is codified at Title 28 of the United States Code, Section 1361.
What does that statute say?
It grants federal district courts original jurisdiction over any action in the nature of mandamus to compel an officer or employee of the United States or any agency thereof to perform a duty owed to the plaintiff. Congress has specifically authorized federal courts to order government officials to perform their legal duties.
Is there any other law that applies to these cases?
Yes, there is a second statute that plays an equally important role in immigration delay cases. That is the Administrative Procedure Act, commonly referred to as the APA. The APA governs how federal agencies must operate.
What provisions of the APA are relevant?
Two provisions are particularly relevant. Section 706 of the APA authorizes courts to compel agency action that is unlawfully withheld or unreasonably delayed. And Section 555B states that agencies must conclude matters presented to them within a reasonable time.
So the APA creates an independent legal basis for challenging delays.
It does. When someone files a federal lawsuit challenging an immigration delay, they typically assert claims under both the Mandamus Act and the Administrative Procedure Act. These statutes provide complementary legal foundations for the same underlying problem, which is government inaction on a pending application.
What must a plaintiff establish to succeed on a mandamus claim? What are the legal elements?
Courts have identified three elements that must be satisfied. First, the plaintiff must demonstrate a clear right to the relief they are seeking.
How does that apply in immigration delay cases?
It means the applicant has a properly filed application pending with the government. They submitted the required forms, they paid the required fees, they provided the necessary supporting documentation. The application is complete and pending. They have a legal right to have that application adjudicated. That is the clear right.
So they have done everything they are supposed to do on their end.
Exactly.
What is the second element?
The second element is that the government defendant must have a clear, nondiscretionary duty to act. This is where immigration law provides strong support for applicants.
Explain that.
Under the Immigration and Nationality Act, USCIS and other immigration agencies have a statutory obligation to adjudicate applications for immigration benefits. The agency has discretion over whether to approve or deny any particular application, but the agency does not have discretion over whether to decide the application at all. The duty to adjudicate is mandatory, not discretionary. The government cannot simply refuse to act. It cannot let applications sit indefinitely without review. The law imposes an obligation to process cases and render decisions.
And the third element?
The third element is the absence of any other adequate remedy. The plaintiff must show that there is no other legal avenue that would provide the relief they need.
In the context of immigration delays, how is that element typically satisfied?
When an application is pending with no decision, there is nothing to appeal. You cannot file an administrative appeal of a non-decision. There is no denial to challenge through the agency's internal review process. The applicant is stuck with no administrative recourse. And that is exactly the situation where mandamus becomes appropriate. The absence of an administrative remedy is what opens the door to federal court.
Once someone establishes these three elements, how does the court decide whether to grant relief? What standard does the court apply?
This brings us to what are known as the TRAC factors. TRAC stands for Telecommunications Research and Action Center. It refers to a 1984 case from the D.C. Circuit Court of Appeals called TRAC versus FCC.
What did that case establish?
The court in TRAC identified 6 factors that courts should consider when evaluating whether an agency delay is unreasonable. These factors have been widely adopted by federal courts across the country, including in immigration delay cases.
Let's go through them. What is the first factor?
The first TRAC factor asks whether there is a rule of reason governing the time frame for agency action. Courts look at whether the agency is following a rational schedule for processing cases. If the agency is taking far longer than its own stated processing times, that weighs in favor of finding unreasonable delay.
So the agency's own benchmarks can be used to measure whether the delay is excessive.
Yes.
What is the second factor?
The second factor is whether Congress has provided a timetable for agency action. Some types of immigration applications have statutory deadlines. When Congress has specified a time frame and the agency has exceeded it, that is strong evidence of unreasonable delay.
Can you give an example?
For EB-5 investor cases, the statute requires USCIS to adjudicate the I-829 petition to remove conditions within 90 days. When the agency takes years instead of 90 days, that statutory deadline becomes a significant factor.
What is the third factor?
The third factor examines the effect of the delay on human health and welfare. Courts consider the real-world consequences that the applicant is experiencing because of the delay.
What kinds of consequences matter?
Family separation is a major one. If spouses or parents and children are living in different countries because a visa has not been processed, that is a significant human welfare impact. Inability to work legally is another. Financial hardship, career disruption, educational opportunities lost. Courts take these human costs seriously.
So the delay is not just an abstract bureaucratic problem. It has tangible effects on people's lives.
Exactly. And that is what the third factor captures.
What is the fourth factor?
The fourth factor considers the effect of expediting the delayed action on agency activities of a higher or competing priority. This factor typically favors the government.
How so?
The government often argues that if the court orders expedited processing of one case, it will divert resources from other cases or higher priority activities. Courts recognize that agencies have limited resources and competing demands.
So this factor acknowledges that the agency cannot do everything at once.
Correct, but it is only one factor among 6. It does not automatically defeat a delay claim. Courts balance it against the other considerations.
What is the fifth factor?
The fifth factor looks at the nature and extent of the interests prejudiced by the delay. This is related to the third factor, but focuses specifically on what the applicant is losing because of the government's inaction.
Such as?
Lost employment opportunities, inability to travel, separation from family members, business losses, educational setbacks, the inability to make long-term plans because immigration status remains uncertain. All of these are interests being prejudiced by delay.
And the sixth factor?
The sixth factor asks whether the agency has acted in bad faith or engaged in impropriety. Courts consider whether there is any indication that the agency is deliberately stalling or acting for improper reasons.
Is bad faith required to win a delay case?
No, and this is important. A plaintiff does not need to prove that the government acted in bad faith. The absence of bad faith does not excuse an unreasonable delay. But if there is evidence of bad faith, that strengthens the plaintiff's case significantly.
So the TRAC factors provide a framework for courts to weigh all the relevant considerations.
That is right. No single factor is necessarily decisive. Courts look at the totality of circumstances and balance the factors to determine whether the delay has crossed the line from ordinary processing time into unreasonable delay that warrants judicial intervention.
What types of immigration cases can be addressed through mandamus?
The range is broad. Mandamus can apply to virtually any situation where the government has a duty to adjudicate an application and has failed to do so within a reasonable time.
Let's go through some common examples.
Adjustment of status applications are one of the most common. These are filed on Form I-485 by applicants seeking lawful permanent residence, commonly known as a green card. Delays can occur at multiple stages. The applicant may wait years for an interview to be scheduled, or the interview may happen and then years pass with no decision.
What about citizenship cases?
Naturalization applications filed on Form N-400 are another frequent category. Applicants may experience long delays before their naturalization interview. Or the interview happens and USCIS fails to render a decision afterward. There is actually a specific statute for naturalization delays, 8 U.S.C. Section 1447B, which gives federal courts jurisdiction when USCIS fails to decide within 120 days after the examination. We will cover that in detail in a future episode.
What other case types?
Employment authorization delays are significant because they affect the applicant's ability to work legally. Asylum cases frequently involve long delays, both for initial interviews and for final decisions. EB-5 investor visa cases often involve multi-year waits for I-526 petitions and I-829 petitions.
What about cases at U.S. embassies and consulates?
Consular processing delays can also be addressed through mandamus in certain circumstances. This includes cases stuck in administrative processing under Section 221G of the Immigration and Nationality Act. Consular cases do present some unique jurisdictional questions because of a doctrine called consular non-reviewability. We will address those complexities in a dedicated episode.
But the core principle remains the same across all these case types.
It does. The applicant has a properly filed application. The government has a duty to adjudicate it. The government has unreasonably delayed. Mandamus provides a remedy.
Describe what happens procedurally when someone files a mandamus lawsuit.
The process begins with drafting and filing a complaint in federal district court. The complaint is the legal document that initiates the lawsuit. It identifies the plaintiff, names the defendants, explains the factual background, and sets forth the legal claims.
Who are the defendants in an immigration mandamus case?
The defendants are typically the government agencies and officials responsible for the delay. This usually includes USCIS as an agency, the Department of Homeland Security, and specific officials named in their official capacities, such as the USCIS Director and the Secretary of Homeland Security. For consular cases, the Department of State and relevant officials would be named.
After the complaint is filed, what happens next?
The complaint must be served on the defendants according to specific procedural rules. In cases against the federal government, this includes serving the United States Attorney for the district where the case is filed, and the Attorney General of the United States.
Then, the government must respond.
Correct. The government is given a period of time to respond to the complaint. The case is assigned to an assistant United States attorney who handles litigation on behalf of the government. That attorney coordinates with the relevant immigration agency.
What typically happens at that point?
In a significant number of cases, the filing of the lawsuit itself prompts the agency to act. Once the agency knows there is a federal lawsuit pending, the case receives attention it was not receiving before. USCIS may schedule an interview or issue a decision on a case that has been pending for years.
So the lawsuit can produce results without ever going to trial.
Frequently. The agency would rather adjudicate the case than litigate about why it has failed to adjudicate the case. Many mandamus cases end with a stipulated dismissal, where the government agrees to act by a certain date and the plaintiff agrees to dismiss the lawsuit once that action is taken.
And if the government does not voluntarily act?
Then the litigation proceeds. The government may file a motion to dismiss, arguing that the delay is not unreasonable or raising other legal defenses. The plaintiff responds to that motion. The court rules. If the case survives the motion to dismiss, it proceeds toward a decision on the merits.
Does the case typically go to trial?
Full trials are uncommon in mandamus cases. Many are resolved on motions practice or through settlement. But the possibility of a court ruling creates the pressure that often leads to resolution.
There is a question that many applicants have before pursuing this remedy. Does filing a lawsuit against the government hurt the underlying immigration case?
This is one of the most common concerns, and the answer is no. Filing a mandamus lawsuit does not adversely affect the immigration application.
Why not?
Several reasons. First, mandamus is a standard, legitimate legal remedy that has been part of American law since the founding of the country. Exercising this legal right is not improper or adversarial in a way that should affect how the agency views the merits of the case.
How are immigration applications supposed to be decided?
Immigration officers are required to adjudicate applications based on whether the applicant meets the eligibility criteria established by law. The question is whether the person qualifies for the benefit under the relevant statutes and regulations. Whether the applicant filed a federal lawsuit to get a decision is not part of that analysis.
Are there protections against retaliation?
Yes, government regulations and policies prohibit retaliation against applicants who exercise their legal rights. The procedural question of whether the delay was unreasonable is legally separate from the substantive question of whether the applicant is eligible for the immigration benefit.
So applicants should not hesitate to pursue this remedy out of fear that it will backfire.
That concern is understandable, but not supported by how the system actually operates. Filing a mandamus lawsuit is far more likely to result in the case finally being decided than to cause any negative consequence.